Hello, my name is Nate Whitaker and I'm an attorney at the Franchise and Business Law Group, and today we are going to be talking about common mistakes in forming an LLC. And this is something that we do a lot at our firm. We help people when they're forming a business to try to avoid a lot of the common mistakes that we see walk through our door. One of the common mistakes is not having a very well-written, well-defined operating agreement. Utah law allows oral operating agreements now. That's a new law that was recently passed, and this has created some areas of ambiguity. And having a well-written, very clear, well-explained operating agreement will help avoid a lot of those problems with member disputes in an LLC. One other problem that we see often is not having the members' roles in an LLC and their responsibilities very clearly defined. So often one or two or three people will get together, they'll form an LLC, and they will just start operating business, and naturally they'll kind of flow into different roles. The problem arises when those members' roles are not clearly well defined in the operating agreement or in an employment agreement or membership agreement, and the one member might not be pulling his or her weight, and or someone else might think that they're doing more work than, or different work than someone else. And having those roles clearly defined will avoid a lot of those problems. One other common mistake is not having a plan for exit. A lot of members, again, will form a company, start operating, and then if some member wants to leave, that becomes ground for a dispute, where one member thinks that their share or their interest in the company is worth more. Other people may think it's worth less, and they may be kind of stuck. They may not be able to sell because the company may not have the cash to buy their interest, or they may not be able to find a buyer for their interest. And so having a well-defined plan will avoid a lot of those mistakes. Another common mistake is knowing what the members are going to do if there's a dispute, whether the members are going to immediately go to mediation, whether they're going to immediately go to arbitration, whether they're going to bring in a third party to try to talk sense into the members. That is something that we found successful in the past. So having that clearly defined is a good idea. One other common dispute for LLC members is co-mingling of assets, meaning that the individual members may commingle their assets in with the business assets, or they may pay personal expenses from business funds. And that is something that is very hard to unwind after it's been going on for a little while, and after the business is either trying to sell to a new buyer, whether there's a dispute and they're trying to break apart the business. That creates a lot of problems. And one common mistake regarding that is regarding not keeping an accurate capital account. So a capital account keeps track of each member's assets, liabilities, and we have a lot of clients or people that walk through our door that don't keep an accurate capital account, that we have to help them fix, again, when they're trying to sell the business or there's a dispute. And so we can help you with these types of things. These are very common mistakes that we see from clients and here at the Franchise and Business Law Group. So give us a call and we will help you with these issues.